All right, so get this. Have you ever heard of someone losing a lawsuit before they even got to say a single word? Like the whole thing is over before it even starts. Well, we're about to unpack a real court case where that is exactly what went down. It is a wild story, folks, all about a homeowner, their HOA, and, believe it or not, a very, very empty chair.
So let's put you in the driver's seat for a second. Imagine you're suing your HOA. You've jumped through all the hoops, you've filed all the paperwork, you are ready for your day in court. But when that day finally comes, you're a no-show. What do you think happens? Well, we don't have to guess because we're going to look at a real case that gives us the answer.
Okay, first things first, let's meet the players in this little drama. On one side, we've got the homeowners, Stephen and Elizabeth Tosh. And on the other side, their homeowners association, the Cimmarron Superstition HOA.
Okay, some quick legal lingo here so we're all on the same page. The Tosh, since they're the ones who filed the lawsuit, they're called the petitioners. Think of it like they're the ones petitioning the court. The HOA, well, they're the ones being sued, so they're the respondent. They have to respond to the lawsuit. And trust me, knowing who is who here is absolutely crucial to understanding why this all went down the way it did.
All right, Section 2, the day in court. The stage is set for a legal showdown. So, after a bit of a delay, a final firm date was locked in. Everybody got the notice, and the hearing was officially on the calendar. The showdown was coming.
So let's look at the timeline, because this is where it gets interesting. Back on May 12th, the hearing gets continued to a new date. That new date, June 24th, 2022 at 9 a.m. And that date sets up this critical 15-minute window that honestly is going to decide the entire case. 15 minutes, that's it.
Okay, the big day arrives. It's June 24th, 9 a.m. on the dot. The hearing officially begins. The administrative law judge, Velva Moses-Thompson, is there, ready to preside. The HOA's lawyer, Christopher Hanlon, is at his table. The stage is set.
So let's do a quick head count, right? We've got the judge, check. The HOA's lawyer, check. But what about the petitioners, the Toshes, the very people who started this whole thing? Nowhere to be seen. Their chairs are completely empty. A huge red flag, right from the start.
So we move into the 15-minute wait. The clock starts ticking on an empty chair. Now you might think the judge would just bang the gavel and call it a day, right? But nope, there's a procedure for this. She decides to wait. And this is where that ticking clock really begins to matter.
And the cool thing is, we don't have to guess what was said. We have the actual audio transcript from the hearing. The judge goes on the record and says, and I'm quoting here, "I don't know if they're planning on appearing today. I will wait. I give both parties a grace period of 15 minutes here." So it's official. They have 15 minutes.
And so, they wait. Can you imagine being in that room? The judge, the HOA's lawyer, the court reporter, just waiting. 1 minute ticks by, then 5, then 10. The full 15 minutes of that grace period just evaporates. And still, nothing.
Which brings us to a case dismissed. The judge delivers a swift and final decision. The 15 minutes are up. The Toshes haven't shown, nobody's called, nothing. The grace period is over. It's time for the judge to make the call.
So the judge goes back on the record, and here's the knockout punch. She says, "By failing to appear, petitioner failed to meet the burden of proof in this matter. Therefore, I am inclined to issue a default and dismiss." Bam! Just like that, case closed.
Okay, so the judge just dropped a really important legal phrase on us, burden of proof. But what in the world does that actually mean? Let's break it down.
So the burden of proof is basically the legal way of saying, put your money where your mouth is. It's the responsibility of the person making the claim, in this case the petitioners, to provide the evidence that proves their story is true. If you're the one suing, it's on you to prove your case. The other side doesn't have to prove you're wrong, you have to prove you're right.
And the logic here is actually super simple when you think about it. Step 1, you file a lawsuit making a claim. Step 2, now you have the burden of proof, meaning you have to present evidence to back up that claim. Step 3, well, you can't exactly present evidence if you don't even show up to the hearing, right? Which leads to the final result, the burden of proof isn't met. The case fails, it's like a domino effect.
And that leads us to the final word. The official record closes the book on the case. So, after the judge made her decision in the courtroom, the official paperwork gets filed, it's all stamped, sealed, and becomes part of the public record.
But hold on, the story isn't quite over yet. About a month later, the petitioners, the Toshes, try to make a comeback.
They file something called a Notice of Action Appeal, basically trying to get the case reopened.
So what did the court say to this appeal? Well, their response, written right here in this official minute entry was, let's just say it was pretty blunt. The documents will not be considered because no further action can be taken on the matter. In other words, nope, too late. The door wasn't just closed, it was locked and bolted.
So when you boil this whole thing down, it all comes back to one single number. 0. That's how many arguments were actually heard. 0 pieces of evidence were presented. 0 witnesses took the stand. The entire case, the whole thing, was won and lost on a simple procedural rule, not on the actual facts of the dispute.
And really, this whole story is just a powerful, kind of crazy reminder of one of the most basic rules of the game. Sometimes, the most critical step you can take is just to show up. It really makes you think, doesn't it? How many of these legal fights are won or lost before a single argument is even whispered in the courtroom?